Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on trustees, specifically co-trustees versus individual trustees. Trustees play a central role in every trust. They are the people that you entrust to manage your property, invest it, and distribute it according to your wishes. And so you are relying on them to a great extent. And that decision of who plays in that role is very critical. Now, besides all the number of different people that you may choose, or not just people, but entities, trust companies that you might consider also whether or not you have multiple trustees serving together at the same time or a single trustee acting at a given time. Now, one of the reasons people might be considering this is they have multiple children, and they want to name their children as the trustees, and so they're thinking, do I name them in any particular order, such as age order or by proximity, or other criteria that they might have. Or they might say, well, maybe I need to have all my children serving together. I don't want to leave anybody out. There are a number of reasons that you might choose either way, whether it's all together or one after the other in that way. And to be honest, whether or not that works has more to do with the dynamics of the people involved and the complexity of your trust, the assets in it, and the provisions of your trust, and difficulty carrying those out on what decision is right in that case. Now, in terms of individual trustees, this is I probably do this for clients more often than not is individual trustees, where one acts, and if that first trustee is unable to act, then the next one steps into place. Now, there's certain advantages to that, and one of the primary advantages to that is there's one voice that acts, one person that signs, and so whenever they're dealing with a financial institution, they're making trades or liquidating property, there's certainly some efficiency there in having one person. There's also efficiency there in terms of lower trustees' fees in some cases. You have fewer people that are clamoring for that, though it's not always more expensive to have multiple trustees, because ideally they should be sharing the same trustee fee as they're sharing the load. But it certainly is simplified in terms of you have one voice, one mind, one signature, handling all of the business of the trust. Now, obviously, that means you have a great deal more trust in that person, and so that one person, because they have all that power, can exercise it poorly and create some issues, and as well as whether or not they're doing anything wrong. Sometimes, and this might be a reason that some people consider using multiple trustees, oftentimes those who are not acting as trustee, even if they otherwise have a good relationship before the trust administration, they may find themselves being on the outside, not knowing what's going on, and maybe have some mistrust. That's one reason why a lot of people will do a co-trustee situation, where they have multiple parties acting together. Now, there are lots of different scenarios where you might find that. Just dealing with a situation where they're settling the trust after death, it's all the kids, they're the beneficiaries and they're the trustees. There are certainly a lot of things that can go wrong with having multiple trustees. Now, it doesn't mean it's not the right decision in your case, but you have more voices, you have more minds to argue over things and disagree over things, and in many cases it can be more complicated conducting trust business because they have multiple signatures. Now, there are some things that we can do to mitigate that. Sometimes we'll have documents drafted up depending on your situation and why you have co-trustees. Sometimes it's a matter of saying, okay, any one of these trustees can act, and the signature of any one trustee is sufficient. And sometimes that works. Sometimes financial institutions will, because they're concerned about liability, they'll require all the signatures all the time, or they'll require additional documentation in order to act on that. But what you often get is there's still one voice that emerges as the primary person. And sometimes the main reason why people often will do a co-trustee situation here is not necessarily because they want everybody's hands into the pot, but they want everybody to have the information available to them. What doesn't always happen is that information doesn't always get shared. Sometimes there's a stronger personality who even though supposedly they're co-equal. As a legal matter, they're co-equal with their co-trustees. They'll kind of grab the power, or grab the information, or kind of not communicate well, and not seek consensus before making decisions. So really, it's not a simple calculation in your case. It's something where you have to look at the dynamics, you have to look at the personalities involved. Um, because a lot of times the co-trustee situation, well, there's multiple reasons. One might be that access to information and communication. If they're already good communicators, and if you are only doing it so that people can have access to the same information, and there's not a concern about one person kind of emerging as the primary voice, then that might work very well. That one person can act, and they're able to conduct that business. And there's fewer of the complications of having multiple voices, and the other people get information. Another reason where or another scenario where it might work well with co-trustees is where you have, and you might set it out as this person being the primary. You have maybe a beneficiary who has their own trust, and you want them to have some training, another person who's a little more mature, can help them make business decisions. And then having another person as a co-trustee in those situations can work very well in terms of there's some training, there's an opportunity for that beneficiary to be involved, but not have full control. And so that's a situation, again, where co-trustees work really well in that scenario for that particular purpose. There are ways of dealing with conflicts between parties that work okay. But if we're dealing with dealing with family, a lot of times, whether it's individual or multiple co-trustees acting together, there still can be a lot of conflicts, and you really have to analyze what are the personalities involved, and how are things going to change when money and time, and because it takes a while for administration to go through, how are they going to manage this and relationship during that process, and is this the right fit for my family? It takes some analysis, it takes some considering that, and a lot of times neither solution is really going to deal with a personality conflict or anything that you can anticipate ahead of time that's severe. Many times it's best to consider not whether you have one or two or three or four trustees acting at the same time, but perhaps going away from interested trustees to a third party, and oftentimes leaving other family members out of the picture because they're not always unbiased, and going for a professional trustee. If you have questions about your trustee appointments, the trustees nominated in your documents, if you're considering how to set that up, whether it's multiple co-trustees or individual trustees, one after the other, we can talk with you, go through those personalities, discuss your family environment, and help you make the best decision for you and for your trust. So hope that you'll give us a call, and look forward to seeing you next time.